thank you all for joining us for this ABA section of Civil Rights and Social Justice Chair Chat. I am Lauren Stiller Rikleen, a proud former chair of this section and the executive director of Lawyers Defending American Democracy. And I am really thrilled to be able to welcome you all to this conversation that we are having. These chair chats in general offer a very special opportunity for engaging with the issues that are at the heart of the ABA's work in civil rights and social justice that helps explore perspectives of various expert panelists that agree to devote their precious time to these conversations and most importantly, spark action on the part of those who are watching and participating. These are all values shared by lawyers defending American democracy. So I'm just so thrilled to be able to have these hats on as I have the opportunity to spend time with one of my very favorite law professors in the world, Scott Cummings. And as I will describe, and you will hear from him, this particular conversation is so critical to the times that we are in, and Scott's work is so critical to all of us as in the legal profession. Scott is the Robert Henningsen Professor of Legal Ethics at UCLA School of Law. He is known internationally for his work on the ways in which lawyers play a role in contributing to backsliding democracies. His writings about our profession and how lawyers help countries move into autocracies should be must reading, as well as a wake up call for our profession. So, Scott, welcome to my ABA home and the section that leads so much of the ABA's important civil rights and social justice work. I'm excited to have you bring your scholarship to the American Bar Association and simultaneously provide a repeat appearance for LDAD's audience. And wearing my ABA former section chair hat, I want to just quickly note that this section, although it's very blessed with volunteer talent from around the country, it's important to particularly thank the staff and those who help make all of this good work actually happen. So a shout out and a thank you to Paula Shapiro, the section's director and chief counsel, and Ali Kilsgaard, the section's associate director, for all the work you do behind the scenes to make everything happen, including, in particular, this conversation. So, Scott, our conversation today focuses on an essential theme of your work, and that is the way that you shift the scholarly lens from the view of lawyers as defenders of democracy to the ways in which lawyers are the authors of autocracy. Your most recent law review article is called The Autocratic Legal Playbook, and in it you describe the brutally efficient way in which law is being used to destroy democracy in the United States. Very ominous words, but really important for us to understand. So please help us understand exactly what you mean when you talk about the term autocratic legal playbook.
Thank you, Lauren. I just want to start by saying thanks to the ABA and the section and Lawyers Defending American Democracy for hosting this event and for just more broadly shining such an important spotlight on the role of lawyers in democracy and what we can do to strengthen it in this critical time. Thank you for introducing my work on the Autocratic Legal Playbook. The Autocratic Legal Playbook is really, I like to think of it as a kind of legal toolkit that authoritarian-minded leaders use to dismantle checks on executive power. And the playbook is kind of a set of ideas that's called together by authoritarian leaders based on studying how democracies die. And it sort of generally says that if you're an elected leader who wants absolute permanent power, the most effective way to do that is not by force in the old model of a military coup, but by appearing to follow law, by what I call sort of exploiting legal loopholes in the constitutional system, by taking executive action that are legal in appearance and in form, but really have the ultimate goal of systematically dismantling the independent institutions that support the rule of law by limiting executive power. And the idea of the playbook is that if you study what other autocratic countries or backsliding countries have done, the kind of institutional targets of the playbook are clear. So every autocratic leader goes after a set of institutions, right? They seek to capture the courts, install loyalists in the bureaucracy, silence political dissent by taking over universities, civil society, the media, and really importantly for our conversation today, co-opting the legal profession, intimidating law firms, taking over bar associations, and preventing lawyers from representing interests against the government. And the big idea is that this is really important to autocratic leaders, because if you get rid of the independent legal sector, right, if you get rid of independent courts and independent lawyers, there's no one left to keep you within legal boundaries. You get to define what the law is, and there's no one to stand in your way. So this is the kind of ultimate objectives of autocrats, to define the meaning of law and therefore act without legal consequences. And this is what I suggest in the article is what we are seeing happening today.
And that's a really helpful framing of the of what is happening, and putting it in these well researched historic terms. You talk about a very specific set of principles that the autocratic legal playbook relies upon to weaken democratic institutions through the law. And every day it seems like we are seeing examples of these principles that are playing out. And then we watch the media just right down that rabbit hole, chasing whatever it is that has been thrown down that rabbit hole to divert the media from whatever it is that is the administration is actually doing that we should be paying attention to. It's really important, I think, that people understand how these specific principles are constantly being employed in actuality. So let's talk about some of these principles, and can you describe some of them, and this dynamic that we are seeing?
So I think so from the biggest perspective, the big idea is that what this autocratic legal playbook is designed to do is to really kind of foster distrust in democratic institutions as a way of kind of clearing away people's preconceptions that they're working in favor of them and of supporting democracy in a way that works for them, and then kind of clearing out that idea in order to justify executives and aspiring autocrats to execute emergency powers that really override what we think of as existing legal institutions and legal norms that we followed for a long time. And so there are several different ways in which this idea of promoting democratic distrust to kind of justify emergency authority, emergency legal powers by autocratic leaders happens. And one of the key ways that I discuss this happening in my work is through this lens of inverting reality or subverting truth as a way to really manufacture legal authority in ways that, again, sort of expand into this realm of exerting emergency power. And there are a bunch of examples of this truth subversion in the service of kind of creating a veneer of legality to justify what are otherwise illegal actions that we can see going on in the Trump administration. There are many, many examples. And so, I think maybe helpfully spotlighting a couple of them might illuminate how this works in practice. The first one that I would spotlight is it relates to the summary detention and deportation of immigrants without due process in violation of U.S. immigration law and constitutional legal principles applying to immigrants under claimed wartime authority. I think the most famous example of this, or notorious example of this at this point, was in March when President Trump deported 100 Venezuelans in spite of a district court order on the grounds that they are part of a terrorist organization. The gang Tren de Aragua was labeled a terrorist organization, and that terrorist designation was used to designate members of the gang as effectively wartime enemy combatants, and therefore depriving them of any statutory or constitutional protections they would have, which would normally allow them to challenge the terms of their detention and deportation. The legal authority that was invoked for this process was the Alien Enemies Act of 1798, which permits the president to deport non-citizens when there's either a declared war or there's a, quote, invasion or predatory incursion. The reality inversion is that President Trump issued an executive order, a proclamation in March, declaring that the Venezuelan gang Tren de Aragua was engaged in an invasion of wartime proportions that then justified the invocation of presidential wartime authority to circumvent the existing legal protections that they would otherwise have and deport them in that very high profile case in which Judge Boasberg ordered the planes to come back and they did not. So again, this is the example of kind of trying to fit within established legal categories that are then distorted because of distorted factual predicates. Again, here the idea that a U.S. gang is engaged in a wartime invasion to justify what would otherwise be clearly illegal conduct. I think in this regard, it's not accidental that this gang is associated with Venezuela, and we've seen subsequent to these deportations these military strikes against purported drug boats in the Caribbean off the coast of Venezuela, and now a military buildup on the coast of Venezuela, adding to this narrative, again, false narrative, this inverted reality that we are somehow at war with Venezuela, which justifies a whole range of actions, including these illegal deportations. So I think that's one illustration. The second illustration of this kind of inverting reality to create or manufacture legal authority for what would otherwise be illegal acts, I think it focuses on the mobilization of the National Guard to a number of American cities, including my own, under a federal statute that allows the president to effectively do this and importantly bypass consent by the state's governor if specific legal predicates apply and are met, which include being unable to execute federal law with regular forces and also to put down a rebellion against the United States. So again, these concepts of rebellion and inability to execute federal law are important established legal concepts. And what happens with these playbook principles is that they are then mobilized by virtue of creating false facts to kind of fit within them to justify at least the appearance that the mobilization is legal when in fact it's not. So in Los Angeles, Portland, Chicago, a case that's now on appeal to the Supreme Court, government has effectively argued that what have been by most accounts generally peaceful protests against ICE raids on immigrant communities constitute a form of rebellion that justifies invoking this federal statute, putting National Guard troops on the ground, and bypassing gubernatorial consent in the process. Again, this is only possible if one buys the underlying factual assumption that there is a conspiracy against the United States, which of course there's not by any objective measure. And so this is sort of taking facts, putting them upside down, and then using those inverted reality ideas to then justify what again would be otherwise illegal action. So this is the sort of basic move that's kind of at the core of this idea of the autocratic playbook.
That's extremely helpful. And another example of the playbook principles that you give has to do with one of my biggest pet peeves, and that is the use of false equivalencies. We see false equivalencies come up now in every conversation where we're raising some of the concerns that we're discussing today, or generally with the hundreds of these executive orders and their question legality, and the answer is but some other administration did something. Can you provide some examples specifically that you're seeing right now of how this false equivalency use is working to undermine our ability to have conversations about what is taking place today and the problems with what is taking place today, and how maybe we can more effectively push back when you're trying to have a conversation about the illegality or unconstitutionality of a particular action, and somebody wants to talk to you about something that happened, 15 years ago.
Yeah, I mean, I think this is a really, really important problem and a very difficult one to address effectively, but we have to be able to do it in order to actually make principled decisions about what's legal and what's not legal. And I started to think about this idea of false equivalency actually in the context of the 2020 election, where the that we had lawyers who have now been sanctioned, including John Eastman, who wrote memos justifying the presentation of fake electors to Vice President Pence on January 6th and asked him to count them, even though they shouldn't have been presented and had no basis in law. And the justification that was given by Eastman, in part, relied on some articles that had been written by liberal constitutional scholar Lauren Stiller, in which he justified the presentation of dual slates of electors in contexts in which there were actual legitimate disputes ongoing about the outcome of elections in Florida in 2000 famously, and then in Hawaii in 1960. And the idea was that because tribes said it with respect to these other contested elections, it was therefore justified in the context of 2020. But of course, there was a huge difference, which was that in these other contexts that tribe was identifying, there were actually legitimate disputes about the outcome of the election that justified preservation of rights, whereas in 2020 there weren't. And so this idea of, they did it, so therefore we can do it, and it's all the same, has then become kind of a bedrock governance principle to justify, again, all sorts of actions that should not be justified. And I think, that the big example that, and I think and one of the most egregious examples now is this idea of weaponization in the Justice Department. And the claim that's been made by the Trump Justice Department and in an early Trump executive order right on the first day in office on the weaponization of the federal government is this idea that the Biden Department of Justice engaged in investigations and prosecutions that were politicized, that were political in nature, that were in Trump's language, political witch hunts, and these include legitimate, very careful investigations and prosecutions against Trump himself for election interference and mishandling of classified documents, and also against January 6th insurrectionists for a variety of crimes, including violence against Capitol law enforcement officers. And the idea is that because falsely claimed equivalency, the Biden administration engaged in political investigations and prosecutions, that justifies a couple of things. One, cleaning house and in purging the department of any lawyers that had any involvement in any of these activities. And we've seen that happen, the staff that was involved in the election interference prosecutions, January 6th is all effectively gone. And then second, essentially weaponizing the Department of Justice to go after the people who were involved in these prior legitimate prosecutions and investigations, claiming them as political enemies of the state, and it's sort of effectively doing the precise thing that you claim to be fighting against. And so this weaponization idea is, so it's been very powerful, and again, sort of trades on the idea that they did it, and therefore, we're actually countering that, but in fact doing the same thing that we're criticizing. And it's both a legal strategy, I think it's important to point out, but also it's a media strategy. And so there's a kind of coordinated effort to justify actions based on, again, a lot of truth subversion and false facts. So there's been a whole apparatus mobilized to justify the pardons of the January 6th insurrectionists, many of whom again engaged in violent attacks on the Capitol, by reframing what they did as sort of peaceful protests. Trump has called it a day of love. There's been events to celebrate what happened on that particular day. And so turning it upside down in terms of its meaning, and then using it to go after people in the precise ways that the administration claims to be fighting against. And I think this is the sort of the boundary that they've been pushing quite effectively. That's made it hard to fight back. But I think we are fighting back and must continue to define the distinctions between these different kinds of abuses. And with respect to the weaponization, the key crossing line now has been the indictment of James Comey and Letitia James. And I think one of the positive things, hopefully, that will come out of these is the collapse of the prosecutions because of the lack of really any credible evidence, and the public attention that has been brought to the fact that these are political prosecutions that have been brought on the basis of of political demands that don't have any grounding in prosecutorial evidence and discretion. And I think this is bringing these facts to light, continuing to focus on them, raise public awareness is the thing that we have to continue to do, because that's the only way to continue to push back.
Yeah. I'm struck listening to you by the repeated nature in which we see these problems come up, um, and 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 the frequency is such that the media doesn't keep up with the challenge, and yet here we are as rule of law advocates. We're watching in real time the destruction of the Department of Justice as we have always known and revered it, and it's adding insult to injury, we're even seeing the language of weaponization being weaponized, against people who are simply trying to protect the justice system and the rule of law. And I keep, the last few days, I have been thinking a lot. What was so concerning about the Deputy Attorney General's presentation and remarks at this conference is the idea that he's rallying lawyers in the audience and a lot of young lawyers to the battle, the fight against the judiciary. And then he's viciously attacking the judges for what he deemed to be unconstitutional rulings against the administration, which essentially ignores what their job is as judges to do and the decisions they are supposed to make. And these again, we saw little coverage of that. There was some legal press coverage, but by and large, I think much of the world missed the significance of this kind of statement coming out of the number two person in the Attorney General's office. And I'd love some of your thoughts on that and how it relates to these points.
Well, that's a great example. I think back to kind of original ideas here. This notion of the autocratic legal playbook again is focused on knocking out guardrails on the exercise of executive power and knocking out independent legal checks on executive power. And so, government lawyers are super, super important in effectuating the autocratic legal playbook, because you need government lawyers to to draft and to defend laws that are put out, and also to mobilize them in ways that put pressure on enemies, like we're seeing with the Justice Department prosecutions right now. So I think spotlighting government lawyers, understanding the importance of the Department of Justice, understanding its important historical tradition of independence that really was codified after Watergate, and has been carried forward through successive administrations, whether they're Republican or Democrat, is really important. And what Todd Blanche said to this Federal Society meeting, I think, is really the culmination of several months of a very rapid dismantling of that norms of independence and the structures that have been supporting it for the last roughly 50 years. And this has been, again, part of this systematic, very coordinated, well thought out plan to depopulate the department with lawyers that have been inculcated in the norm of independence, who have brought cases based on considerations of fact and law and not for political reasons, and to put in place lawyers from the top down that effectuate this strategy of, of effectively weaponizing or mobilizing the department as kind of the personal legal arm of the president himself. And this started at the very top at the beginning. Todd Blanche was obviously one of President Trump's private defense lawyers, and prior to his 2024 election, Emile Bove, who was previously in his shoes, was also a private defensive lawyer, now Third Circuit judge. So one idea is to put people in the top positions who are 100% loyal and will be willing to push envelopes and engage in the kind of dismantling of these structures and norms of independence that are really critical. So that's kind of one of the important early steps. And then getting rid of people who would pose any resistance to that, right? I think another background point that's really important is that the Department of Justice became a real focal point of I would say, capture by the administration, precisely because in 2020, when Trump tried to overturn the election, one of the moves was to get the Justice Department to endorse the false claim of voter fraud, and there was a whole effort to do that. That was ultimately thwarted because top DOJ lawyers said no. And so lesson learned was, we're not going to have that happen again. People put into place in power that are going to endorse even the most egregious and illegal actions that potentially could be put into place by the president. So I think getting rid of sort of mainstream lawyers committed to the rule of law and putting in loyalists that are willing to do things like Todd Blanche did at that meeting, which are really line crossing and dangerous for democracy, is a really critical part of this. And then I think we can look and trace in terms of this autocratic legal strategy, specific legal actions. Again, the idea is of autocratic legal playbook is to kind of use the forms and language of law in order to justify things that are ultimately undermining and weakening these democratic institutions. And so there's the weaponization executive order that we've already talked about. The first thing that Pam Bondi did when she took office as the Attorney General is to issue this really important memo which set forth a general policy on, quote, zealous advocacy that, again, looks conventional and legal on its face. And it says that attorneys in the department are expected to, quote, zealously advance and defend their client's interest, then links the client to the president and makes it clear that anyone who doesn't agree with the goals advanced by the president, no matter how extreme, are subject to being, quote, disciplined and potentially terminated. We've seen this then play out in examples that I'm sure many in the audience will know, but are worth linking precisely to this memo. The first happened with Danielle Sassoon in the Southern District when she refused to go along with the deal that was cut by Emile Bove to drop the Mayor Eric Adams prosecution for corruption in favor of his cooperation with immigration enforcement. And the justification that Bove gave was that the prosecution of Adams was a weaponized prosecution from the Biden administration, which of course it was not. And that justified the decision, which was in fact political quid pro quo for support with the administration's immigration policy. Sassoon, a conservative Federal Society lawyer, resigned in protest in a quite courageous action. I think the other example I'll just mention here, which has also gotten a lot of attention, is with respect to the case of Kilmar Abrego Garcia, who was wrongfully, erroneously deported by admission of the administration to El Salvador, despite the fact that he had a legal order blocking his deportation. He was sent to CCOT prison because of a, quote, administrative error. And the lawyer from DOJ that was assigned to represent the government in this case was a department veteran, Erez Rabini, who had actually received awards from the first Trump administration for defending the Muslim ban, and who went into court and honestly and accurately said that he did not know why the administration wasn't returning Abrego Garcia given the error, and admitted that there had been a mistake. The next day he was removed and ultimately he was fired for not arguing the unsupported position that Abrego Garcia was a terrorist, kind of put him into that Alien Enemies Act frame. And Bondi then goes on TV to say that he wasn't acting zealously and referring to her memo. So there's been both a destruction of norms by the depopulation of the department. Roughly half of the staff has been gone, according to the Washington Post. And then there's been this effort to recodify a different set of ethical standards, if you will, that justify what's been, the weaponization of the department against enemies, and also the defense of these positions like the immigration deportations that otherwise would be indefensible.
I want to highlight just one more point from the from your article before we talk and conclude with some proposed ideas and recommendations for people. But I think it's just really important to mention this particular point as well for people who are less familiar with your work, and hopefully this will help induce people to want to read this brilliant law review article. You reference how the Brown decision was an example of building incremental legal arguments over time to shift law and policy. And you rightly point out that is how legal rights have been expanded through the careful development of legal authority over the years. We know that this was most effectively used by Thurgood Marshall for decades as he sought to overturn the oppression of Jim Crow laws. And wearing my ABA section chair hat here, I'll say that this section, every year, its most prestigious award that it bestows is the Thurgood Marshall Award. And on my 50th, I was chair the 50th anniversary, and had one of the great honors of my life to give that award to Brian Stevenson. So, the examples set by the way in which he and his team you really had that steadfast way of trying to change the law, is such an important example historically. But then you describe the co-opting of this type of effort through the more recent creation of pro-regime think tanks and legal rights organizations, where lawyers are essentially using fringe legal theories and mobilizing the legal process in a way to try to give legitimacy to actions that are actually designed to break the meaning of the law rather than expand its opportunities. And you talk about that as the laundering of autocracy, which I think is an amazing phrase, the laundering of autocracy through the legal process. And it's really, I think, an important concept that if you could just say a few words about this laundering approach, as you know, from your writing.
I really like the way that you laid out the backdrop and the question. We can all recall that Brown was won, again, based on the decades of incremental legal victories, right? Building successes, and there were precedents laid challenging separate but equal in small steps, opening up universities and law schools to Black Americans before the full attack on public schools. So it built, right? It built on incremental changes toward the broader goal. And importantly, it was based on real facts of discrimination and subordination of Black Americans. In contrast, what we see now in this kind of again, it's a co-optation of the form, the rhetoric of these legal campaigns to justify actions that are illegitimate, and again, at some base level, actions that are even illegal. So we see the use of the format, sort of the appearance of it to legitimize administrative actions, not toward the end of democratic inclusion, but toward the end of power consolidation and exclusion. I talk about it, so I'll just mention two examples. One actually, again, tax backward, but still is relevant, I think, now, and will be more relevant, I think, next year in the midterm elections, which is back to this myth of voter fraud, which was used, again, almost to overturn the 2020 election, and was raised in the special elections last week, right? The specter of voter fraud. It is going to clearly return, I think, when we get into election season next year. this sort of manufactured idea started nearly 25 years ago after the 2000 election. It has been inculcated by right-wing think tanks. There have been governmental commissions designed to investigate and promote the idea that voting fraud is a significant problem in the American election system. It's not, and there's never been any credible evidence to demonstrate that. But the idea is not to actually prove the case, but to create this distrust that the system isn't working, again, to justify these more extraordinary measures of overriding the way that the election system works in order to tilt the playing field. So I think that sort of was one of the templates for what we're seeing now in the context of the current administration. And I guess the other example that I would point to is it goes to the birthright citizenship issue and the executive order that was put out for birthright citizenship. Birthright citizenship, as again everyone knows, is established in the Constitution. It's settled by a case that's nearly 150 years old. There's never been any challenges to this idea, and it was kind of considered to be completely over until John Eastman wrote an article challenging some of its premises in 2008. And John Eastman, now of the famous attack on the election, and the lawyer who has now been, at least at this point, disbarred in California. 2008, writes an article after the case of Yasser Hamdi, who people may remember as the kind of American Taliban who was detained in Afghanistan, and he was born in the United States to non-citizen parents. He sort of argued, based on that case, that we should reconsider the application of birthright citizenship to people like Hamdi. This was a fringe theory. It was never picked up by any legitimate legal outfits. It started to circulate in far-right organizations and far-right legal thought. It gained no traction. There were never any cases advancing its principles, right? It wasn't like the LDF Brown impact campaign, right? There's nothing to support it. Trump takes office, one of the first things he does is issue the birthright citizenship executive order depriving, purporting to deprive children of parents who are not legally in the United States of citizenship, and they're just drastic and radical and illegal deviation from constitutional understanding and longstanding law. And this is, sort of this idea of sort of starting at the fringe, being cycled within organizations and in the kind of media ecosphere, and then waiting for an opportunity to then, having seeded the environment with the idea that maybe there's something to this notion, right? So people are kind of primed, then codifying it in these executive order, and then making people have to fight it out in ways that are still having really ongoing and quite tragic consequences for people that have to demonstrate that they're entitled to basic benefits of U.S. citizenship. So this isn't Brown, right? This is something quite different and much more sinister.
So that brings us to our final point of conversation here today, which is that one of the most difficult aspects of this moment is how easy it is for people to feel hopeless and to hunker down rather than act. I'm sure you hear, as I do all the time, I can't engage, it's too upsetting. But of critical importance, you point out that the ultimate autocratic weapon is the destruction of hope. So, since for both of us, our work is all about hope and the need for everyone to use their voice and make a difference, let's conclude our conversation with some of the important actions that you outline in your article and you describe as a way to reverse engineer the autocratic legal playbook.
So my message has been sort of twofold. One is that time is critical, time is of the essence. We are behind, right? Autocrats succeed, you study other countries. Success happens because autocrats do get way out ahead, right? They flood the zone, they overwhelm the opposition. They make a lot of progress that stretches the opponent's resources quite thin and demoralizes democratic resistance. And so we need to understand that this is part of the autocratization process, and they have played this initial opening quite well in terms of getting out ahead and putting people who care about our democratic institutions on their heels. So time is critical. We're behind, but there's still a lot of time ahead of us, and there's lots of opportunities for action and resistance. But we need to take advantage of that time to be strategic and to learn lessons and implement lessons of what has worked to stop or at least slow this down in other countries. And this is where I talk about this idea of reverse engineering the autocratic playbook, which is the notion of, the autocrats study what other countries do to implement these policies that undercut democratic institutions. Well, we can also study resistance movements. We can also study what they do, and we can try to preempt some of the actions, make it harder for them to be effectuated, and also to build resistance strategies in a way that can be effective. And I think one of the messages that I'd like to emphasize when I talk about this idea that if you do study the autocratic playbook in other countries, what we see consistently is that the kinds of legal moves that we've been talking about in this conversation, when they're deployed in other countries, they're always deployed toward a singular end, which is the consolidation of permanent power by the leader, right? So understanding that this is designed to go in that direction, right, is, I think, a critical starting point. And so I wanted just to leave with some of the lessons that I've learned from studying this in other countries. And one that really does stand out is this idea of thinking like an autocrat, right? And instead of waiting to see what's going to happen next, pro-democracy movements really have to think ahead by looking at these other moves that autocratic leaders have made and understanding that they are going toward the goal of permanent power. I think resistance efforts can continue to hope, and we should all continue to hope that this worst case scenario doesn't come to pass, but we really have to plan as if it will, because the logic is better safe than sorry, right? The idea is to identify the worst case scenario and then backward map and be prepared to challenge it. I think the other message is that collective action is really key in, again, stopping or at least slowing down. If you study autocracy and counter-mobilization, we do know what does not work, and that's silence, individual deal cutting, strategic capitulation. That really only works to hasten democratic decline. What does work, or at least what has this potential of being effective, even if it doesn't provide any guarantees, is collective resistance generally by the public, and also collective resistance specifically by lawyers. I think it's fair to say, and Lauren, your work has been really critical in promoting collective action and solidarity by lawyers. American lawyers, as a group, have not strongly stood in solidarity, particularly at the elite level, even though there have been really important examples of lawyer action that we need to build on. So I think it's both identifying failures, but also creating opportunities and building momentum based on where we see lawyers actually taking courageous stands and acting together in order to really speak out and promote the values of our profession. And there are a number of examples, I think, that, again, probably all of us are familiar with, but when we add them up and I think put them together, they do demonstrate, I think, a lot of activity that's positive, that is making a difference, that, again, can be built upon in the idea of creating more momentum for broader social change. So we've had deans condemning law firm attacks. We've had hundreds of law firms signing on to amicus briefs. We've had hundreds of former judges writing to condemn the Attorney General for threats on judicial independence. We had a recent Republican appointed judge, Judge Wolf, resign in quite, I think, inspiring terms, really laying out what's happening and the problems that it's presenting for the rule of law. Law students have cutted firms that have cut government deals. Law firm lawyers have resigned in high-profile resignations and really named the problems with their firms, agreeing with the government as a key factor, and how that weakens our collective ability to promote the rule of law. And critically, we have our bar associations, right? We have the American Bar Association making these strong, unprecedented statements in favor of the rule of law, suing the government on behalf of the profession to stop the law firm intimidation policy. Other bars, like my own in California, have made very strong statements in favor
Mhm.
of the rule of law and against law firm targets. These are all super important, and while we might think of them as just one-off, we have to think of them as a group and building on each other to really foster the kind of organizing across ideological boundaries, which I think is a really important element of these activities, and in alliance with non-lawyer movements to really create the foundation for change. The other points I just want to emphasize in conclusion is that one of the other principles of resistance that's really important to illuminate is what I call wrenching the gears. And wrenching the gears means kind of seizing legitimate opportunities to make legal objections and use available legal processes to slow this thing down, right? To hinder the playbook's execution and sort of rather than sort of trying to keep a low profile, right? Not poke the bear, as many people say. Lawyers and legal organizations, the bar, really have to step up and take more assertive action than maybe we have in the past because we're under extraordinary conditions that really warrant it. So because lawyers are really key actors, as we've talked about in advancing the playbook principle, because government lawyers are so central, a critical way of kind of wrenching the gears is to try to hinder their efforts by taking away their right to practice law, or at least shining an ethical spotlight on improper conduct in a way that brings public attention and puts pressure on them not to act. Lauren Eldad has been a leader in doing this. Many other organizations have done that. There's just a bar complaint that was issued against Lindsay Halligan and the Eastern District of Virginia for these prosecutions of Comey and Letitia James. These are really important. They may not succeed on the merits, but they are important, again, in raising public awareness and slowing things down for the administration to justify conduct that is otherwise unjustifiable. So I would just end by saying I think all that makes me feel hopeful still that with strategic action and collective action and solidarity, we can still make change. And what history does teach us, as you already alluded to, Lauren, is that democracies die when people lose hope. That is what autocrats want, right? To convince people that this is normal and we don't have anything to say about it. But democracy survive when people don't succumb to that particular illusion. And small acts really make a difference and can create broader change. I think thinking about attacking the system and all its facets can be demoralizing and overwhelming, but everyone can play a part by doing something small because social movements, democratic movements win when these small acts build into broader resistance and actually are able to push back against the center of power. My final thought is that lawyers can't stop this by themselves, but we do have an important leadership role to play in standing up for professional independence and the rule of law in these perilous times. We have to be working with non-lawyer movements in order to build the kind of collective strategies we need. But because lawyers are at the vanguard of pushing democracy into decline, we must, as a profession, play a leading role in changing its course before it's too late. And I think we can all do this in large and small ways, educating people that law is not just what the president and his lawyers say it is, filing lawsuits. There have actually been lots of successes in court. We often hear about the failure. There's been lots of successes, but even on a more micro level, just representing science, upholding the norms of the profession in the face of this onslaught, I think is just really important to personify that this matters. The ideals of profession matter, and we're going to continue to fight for them.
Scott, thank you so much. On behalf of the American Bar Association section of Civil Rights and Social Justice, on behalf of Lawyers Defending American Democracy, we are so grateful to have you join this section chair chat and share your insights as well as your meticulous international research with us today. I want to wish the section. I'm very happy it's 60th anniversary and a well-deserved good year for all the remarkable work that this section has done throughout its history to make a true difference for this country. And I know that that work will continue and continue to make us all proud of this wonderful section. So thank you, Scott. Thank you,
Thank
ABA,
you.
and thanks for being here today.